Okay, hi, I'm Sarah Harris and I'd like to welcome you to the second webinar organised by the Journal of IP Law and Practice. Today we have an extremely distinguished panel of speakers to discuss EU copyright law. We're very honoured that they've agreed to share their thoughts on this forum. I'll now hand over to Dr. Eleonora Rosati, who will introduce the panel and chair the discussion. The webinar will be recorded and we'd like to remind participants to please mute their mics and videos for the duration. Thank you. Eleonora.
Thank you very much, Sarah, and hello everyone. I hope you are doing well at this challenging time. We would like, of course, to thank you for your interest in CJEU copyright case law and for joining today's webinar. I think that today's speakers need no introduction, but I shall remind attendees who they are just for the sake of completeness. We are very honored to have Lord Justice Arnold with us today. Lord Justice Arnold has been issuing some of the most interesting decisions in the field of IP law, including copyright, and I believe that he holds the record as a single judge for the number of referrals to the Court of Justice of the EU on IP issues. So we are very honored to have him with us today. And then we are also very pleased and delighted to have Nicholas Saunders QC with us. Nicholas is a barrister in London. He specializes in different areas of IP, commercial and media law, and he holds the distinction of often representing the UK government before the Court of Justice of the EU in IP referrals. We look forward to the discussion. As Sarah mentioned, we will be recording this meeting, so I would like to invite everyone to join in the discussion by writing in the chat that you can see in the control panel, and to share your views with us, the panelists, and with the rest of the attendees. So thanks again for joining us. What we would like to do in the time at our disposal today is the following. We would like to touch upon 4+1 issues that have been shaping EU copyright in recent times and address some of the forthcoming challenges for the Court of Justice and EU copyright more generally. I would like to start with something that might seem basic because it has to do with the basic requirements for copyright subsistence, but indeed it is something that has proved very challenging and difficult to understand, and it is when copyright does indeed arise. This is a question that has been often posed to the Court of Justice of the EU. You will remember the seminal decision in Infopack in 2009, which was not a copyright subsistence case. It was a case about infringement, and yet it was the beginning of a season of activism on the side of the CJEU, which has resulted in a number of referrals and decisions which have been shaping the requirements for copyright subsistence, ranging from originality to work, and to some extent also challenging the freedom that many member states thought that they had in respect of requirements for copyright subsistence. The last decision in this series is last September's decision in COFEMEL, in which the Court of Justice addressed the issue of copyright protection of designs. There is currently another referral pending before the court on the question of copyright protection of technical shapes, and that is the Brompton bicycle referral. There has been so far the opinion of the Advocate General, which among other things has also provided a first interpretation of the COFEMEL decision. And I would like to start by asking Lord Justice Arnold to comment on COFEMEL and try and answer the question when copyright does arise and what freedom member states do enjoy in determining requirements for copyright subsistence. Thank you.
I think what we've learned from COFEMEL and other decisions of the Court of Justice is that the freedom of member states is much less than they probably thought they had on the face of the legislation. In particular, so far as the interface between copyright on the one hand and designs on the other hand is concerned, member states' starting point would have been Article 17 of the Designs Directive, the second sentence of which tells them that the extent to which and the conditions under which you can have copyright protection for a design, including the level of originality, is a matter for the national law of the member states. So one would have thought on the face of that provision that member states had quite a lot of latitude. However, the second sentence of Article 17 has been interpreted almost out of existence by the Court of Justice, first of all in the Floss case, and now even more strongly in the Coffermel case. Instead, what we are being told by the Court of Justice is that in principle, there is no systematic objection to cumulative protection, both by design right and by copyright. And that is something that has been confirmed again since Coffermel by the recent Gombok decision. What the Court of Justice has pointed out, moreover, is that the requirements for protections of designs on the one hand and copyright on the other hand are different, and that in principle there is no reason why you cannot have protection under both systems, so cumulative protection. However, what we don't yet know is exactly how far that extends. And the reason for that uncertainty is what the Court of Justice said in the Coffermel case at paragraph 52, where they said this: it follows that although the protection of designs and the protection associated with copyright may under EU law be granted cumulatively to the same subject matter, that concurrent protection can be envisaged only in certain situations. So on the one hand, the Court of Justice is saying that in principle you can have cumulation, but on the other hand, the Court of Justice is also saying that cumulation is only available in certain situations. And what we don't yet know is what the certain situations are. It doesn't seem to be quite as simple as saying, well, you just apply the requirements for copyright protection regardless of whether the subject matter is also protected by a design. And I think in that regard, the Brompton case is going to be very important, because that will shed further light on the extent to which it is permissible or indeed required as a matter of EU law to have different requirements for copyright protection of designs other than those one would have in any other case. And I think, given the direction of travel, it seems likely that the Court of Justice is going to be saying something along the lines of, well, you have to satisfy the requirements for copyright protection, but you must apply those requirements quite carefully and stringently when you are concerned with technical subject matter, such as we have in the Brompton case. But obviously that's to some degree a matter of speculation. The final point I would make at this stage is that, of course, from the United Kingdom perspective, where this leaves us very uncertain is whether it's permissible as a matter of EU law, to the extent that that binds us till the 31st of December this year, to have a system of protection that depends upon having a closed list of subject matter. In the UK Copyright Act, there's a closed list of subject matter, and if you don't qualify for entry into one of the specified criteria of types of subject matter, then you can't be protected, even if you can say that your work is otherwise one that would be protectable by copyright applying the CJEU criteria. So I'll pause there.
Thank you very much. Before turning to Nick's comment, I would just like, take the opportunity to elaborate a bit on what you've said last. Certainly, this question regarding the compatibility between the UK copyright system and the CJEU mandated system regarding subject matter categorization does not seem to be something new brought about by COFEMEL. In fact, if I remember correctly, in one of your decisions, the one in SAS, you hinted at the fact that indeed it might be not a fatal objection to say that copyright does subsist also in something that does not fall within one of the categories, provided that that something is still a work in the sense of the Berne Convention. So this change that we are seeing now with COFEMEL did not start with COFEMEL, but it is something that predates this decision and overall has been subject to an overall ambiguity that has been there for several years, at least since InfoPack. Nick, what is your take on this string of cases?
I think it's as Richard was saying, it's difficult to see where they're going to end, and it introduces a lot of uncertainty. I mean, one thing we do know is that following Lavola Hengelo, cheese is not protectable, the taste of cheese. So the UK legislative draftsman can be rest assured that that can be excluded from protection, but beyond that, we don't know. And whether the harmonisation goes further than Berne is an interesting question. There was a lot of debate in the Lavola Hengelo case about whether member states really thought they were signing up to a harmonisation of the notion of a work, because you don't really see that provision in the Information Society Directive anywhere. And the court didn't grapple with that except sort of negatively. They looked at things that work couldn't be and ruled out the taste of cheese. So, you know, aside from that very small indentation, we're not entirely clear how much harmonisation there's been now.
But, you know, I would like to reassure cheesemakers that perhaps the last word has not been told in this respect, because the CJEU said that until there is a way to identify precisely what the taste is and objectively, then protection is excluded. But perhaps if there is a way to comply with the Lavola Hengelo definition, who knows, that might be considered a work. And the same might be true for perfumes. Before we move on to the second topic, as I mentioned, last February, the Advocate General issued this opinion in Brompton Bicycle, which indeed will be an important case when the Court of Justice decides it. And one of the issues there is that the referring court also asked about the criteria that might be taken into account to determine copyright protection. And according to the Advocate General, a prior IP right might be taken into account, but he also says that the intention of the author might be taken into account. So I would like to ask you whether you think that it is indeed appropriate to consider the intention of the author as something that helps to decide whether indeed there is copyright.
Well, obviously it's a matter for the Court of Justice to tell us what the law is, but certainly taking into account the intention of the author causes difficulties, and we've had plenty of experience with those kind of difficulties in the United Kingdom. Firstly, in our old registered designs law, and secondly, in the context of protection of what the UK statute calls works of artistic craftsmanship, which, at least to some extent, some courts have thought did involve an inquiry into the intention of the author. And it causes obvious problems in terms of evidence and in terms of trying to create an objective and predictable and reproducible test. So certainly it's not something that I would welcome.
Nick?
Yeah, I agree with all of that. I think it's a very difficult test, and it's difficult to know whether, you know, if the test is author's own intellectual creation, which is obviously the Berne language. I mean, you have to presumably intend to create something, but beyond that, it's very difficult to see how you might apply a test in any kind of rigorous way, or how the evidence could be compiled to apply that test before a court. It's a very uncertain way forward if the law were to move in that direction.
Great, thank you very much to both of you. let's now move to a second topic. Another area in which the Court of Justice has been quite active, prompted by referrals from national courts, is the area of copyrights, exclusive rights, in which, of course, a dominant role has been increasingly played by the right of communication to the public, and to some extent, this broad right has come to overlap with other exclusive rights, such as the right of distribution. All these to lead to the recent decision of the CJEU in Tom Cabinet, in which the Court of Justice of the European Union ruled that the provision of a marketplace for second-hand pre-owned e-books will be an infringement of copyright, in primary an infringement of the right of communication to the public if provided without authorization. This decision came at the end of a lengthy legal battle in the Netherlands and was not really welcomed by everyone. There were people who were quite unhappy with the decision, also considering that in the past the CJEU had admitted digital exhaustion in relation to computer programs. So I would like to ask Nick, since you represented the UK government in this case, how you feel about the outcome and what you think might lie ahead for providers of digital marketplaces.
Okay, well, so obviously these are my own personal views. The starting point in relation to that case is you need to understand a little bit about used soft. So that was a 2012 ruling of the Court of Justice under Article 4 of the Computer Programs Directive. What the court said was that there was exhaustion if a copyright holder had authorised that a programme could be downloaded, even if that download was free of charge. And there was much debate following USoft as to whether it permitted resale of other types of work, for example, films or music, and that led in part to the 2018 referral in Tom Cabinet. What Tom Cabinet did was they ran a club where you could join the thing called Tom's Reading Club, and it offered access to books that were either purchased by Tom Cabinet itself or donated to it by other members of the club. If they were donated, members had to provide the original download link for the book that they downloaded and declare that they've not kept a copy of it. So then the collecting societies in Holland then took action against Tom Cabinet and sought an injunction. And the court referred 4 questions to the CJEU. The first is whether the distribution right applies where ebooks are downloaded for an unlimited period at a price, and this is a critical thing in the question, at a price which means the copyright holder has received remuneration equivalent to the economic value of the work belonging to him. So it was a rather carefully crafted first question to make it clear that the Dutch court had found that the original sale of the ebook was at a price which gave the right holder the correct amount of compensation. The second question was essentially, if there is distribution, is there exhaustion of the distribution right? And then the third and fourth questions are, was there reproduction? Now, the Dutch court, did not ask anything about communication to the public, pausing there. This was all about distribution rights and exhaustion and whether copying is permitted under the reproduction right in those circumstances. The case went to the Grand Chamber and 9 member states intervened along with the Commission, who's there in every case. And then Advocate General Spooner looked at the recitals to the directive and said that there was a clear demarcation between a right of public communication and a right of distribution. And said that public communication, the right of communication to the public, applies to all forms of online exploitation of the works. So the Advocate General acknowledged that ordinarily you need a public in the sense of there being more than one person, but said that didn't matter here because the circle of persons that was being offered the work was bigger than the original private circle of the original purchaser. Used soft you could put to one side because it was in relation to a lex specialis, specific legislation to do with computer programs, and an ebook wasn't a computer program. The court, a few months later, provided a similar sort of rationale to its decision, drawing quite a lot on Advocate General Spooner. What it begins by doing is saying that it's for the court to give an answer that's of use to the national court and enable it to determine the case before it, and that may require it to reformulate the questions in order to do so, and it did so in that case. So it reformulated the question about distribution to the public to be a question about communication to the public under a different article of the Information Society Directive. It then said Articles 3 and 4 of the Information Society Directive have to be interpreted in accordance with the provisions in the WIPO Copyright Treaty, and relied on the Advocate General to say that an e-book's not a computer program, and so therefore reached the conclusion that in those circumstances there is a communication to the public by offering the work on the website of Tom Cabinet. No exhaustion is permissible for communication to the public, so therefore there's no possibility of exhaustion. It's an act of communication to the public. Tom Cabinet, following the decision, has shut down, but there is perhaps a chink of light for the budding second-hand e-book entrepreneur. Obviously with this going on YouTube, this is not legal advice. So if you get sued, get your own legal advice. If you could establish from a technical standpoint that only one copy of the work could be downloaded during the period during which the user has access to the work, and after that period has expired, it can no longer be used by that user. So you have some kind of technical means for ensuring that it's a one user by one user access to the work, then the communication is not to a public on the way that the CJEU reasoned the case, and so it's not within the scope of Article 3. So you get out of the reasoning in that case, but you do obviously then have to deal with the questions that were never answered by the court, which are those relating to reproduction and distribution to the public. So yeah, it's probably I'll leave it there, but it's been an interesting case about, and particularly about the jurisdiction of the court in answering a different set of questions to those originally referred to.
Indeed, also because if I'm not mistaken, in the background Dutch proceedings, the liability of Tom Cabinet for the unauthorized doing of acts of communication to the public had been excluded. So that's at least what I read about the case background. There will be, of course, Dutch participants who can confirm that or not, but it is an interesting move on the side of the CJEU, but perhaps not entirely surprising. And the solution found indeed might leave the door open for the establishment of second-hand digital marketplaces in a way that might also make the European regime more permissive than the US one in this respect, because in the US there was a litigation concerning Redigi a few years ago, and also in that case, indeed, Redigi allowed one copy per user, and it guaranteed that the copy will be deleted upon migration, and yet the court concluded that there will not be application of the fair sale doctrine in a digital context, because this would be outside the remit of the US Copyright Act. Richard, do you think that the conclusion of the CJEU in Tom Cabinet is surprising from the point of view also of international legislation, the wording of the InfoSoc directive, and the travaux to the directive itself?
Well, I think it's not at all surprising, in particular because so far as the international plane is concerned, of course, we've got the WIPO Copyright Treaty and the agreed statements, which make it perfectly plain that as a matter of international law, distribution is a right which affects tangible objects and not intangible ones. And therefore, it's not at all surprising that the Court of Justice should have concluded that exhaustion of the distribution right can only apply to dealings in tangible objects and not to anything which is intangible. So from that perspective, I don't think it's at all surprising. And essentially, going back to the point that Nick was making about the reformulation of the questions referred, prior to the reference from the Dutch courts, the debate was very much about, well, was this a question of distribution of tangible objects subject to exhaustion, or was this a question of communication to the public of intangible copies of copyright works? And if you view it in that way, it would seem to be rather clearly on the latter side of the line. And it seems a little surprising, certainly with the benefit of hindsight, that the Dutch court could have thought that A, that was not the case, and B, so clearly not the case, as not even to be referable to the Court of Justice. And therefore, it's not really so surprising that the Court of Justice stepped in and said, well, hold on, you've asked the wrong question here. The right question is about communication to the public. Going forward, I agree with Nick that the interesting question is perhaps the one that they didn't need to answer, which is, well, what about reproduction? As to which, as Nick rightly says, you would require some rather special facts for that really to matter.
So, you know, at the end of the day, the question that now comes to me is whether Usoft was incorrectly decided in the first place, if indeed the digital distribution qualifies as communication, or Nick, you think that the position in Usoft was correct?
I think it probably was, but for the law in Usoft, I mean, as Richard says, the position under the WIPO copyright treaty is quite clear when you, and insofar as the Court of Justice is actually trying to interpret the Infosoc directive by looking at the WIPO copyright treaty, the provisions are absolutely clear. It excludes it's tangible works only. I mean, it actually says I think it's Article 6 actually says tangible works only. So that's a very straightforward piece of interpretation for the court if it's going that route. There's quite a lot in Advocate General Spoonar's opinion about the earlier decisions and whether you can reconcile them all, and he kind of reaches a sort of hesitant conclusion that the law wasn't entirely consistent, but then doesn't really take it much further forward because he doesn't need to, given the conclusion he's reached about communication to the public.
Perfect, or not, who knows? Let's move on to the next topic, which of course is a topic not prompted by any recent decision as such, but it is a topic that has been selected for its relevance and indeed as another demonstration of the activism of this Court of Justice in the copyright field. And it is the question of liability. We all know that primary liability for copyright infringement, direct liability, is something that has been formally harmonized, but there has never been a harmonization on a legislative level of the conditions for a secondary and direct liability, how you want to call it. And indeed, it has been believed for a long time that while member states will need to follow the EU regime when it comes to primary liability, they would maintain their freedom when it comes to secondary liability. This apparent simplicity was swept away by the Court of Justice in a number of cases, perhaps starting from the linking cases like Svensson, but decisively so in the Ziggo Pirate Bay case, which was decided in 2017. And there I think that it is quite telling to read the opinion of Advocate General Spooner once again, who starts his opinion, I think it is paragraph 3 of the opinion, by saying that there had been suggestions that a case like that concerning the liability of platform operators will be a matter of secondary liability regimes and therefore a matter of national law. However, he says a solution left to national courts and national legislatures will not be helpful. There should be a unitary solution adopted at the EU level, and the Court of Justice will be the means to convey this harmonized approach also in this respect. So now there seems to be an autonomous form of EU liability for copyright infringement, which in some cases mixes principles of primary and secondary liability. An example is the relevance that subjective elements have been acquiring. So the question that I have for Richard is whether indeed we are now speaking of an autonomous liability regime that combines principles of primary and secondary liabilities, and if so, what is next for liability under EU copyright law?
So my answer to that is similar to my answer to the first topic that we discussed, which is that this is an area where the Court of Justice's jurisprudence is still a work in progress, and we still haven't yet quite found out what the final destination will be. As you have very clearly explained, what the Court of Justice has done in this area is two things which are slightly contradictory. Firstly, it has adopted a very broad standard of primary liability in the context of communication to the public. So communication to the public as a right of copyright owners has been very broadly defined, as one sees from the example you gave of hyperlinking. Many people argued that hyperlinking should not constitute communication to the public at all. But in Svensson, the Court of Justice decided that, at any rate in certain circumstances, hyperlinking did fall within the scope of communication to the public. So on the one hand, we have communication to the public being broadly defined as a right of a copyright owner, and therefore that carries with it ordinarily the right to exclude others. But in tandem with that, and particularly we saw this in the trio of cases GS Media, Filmspieler and Pirate Bay, we have the Court of Justice doing something which is actually somewhat contradictory, which is to say that rather than adopt the traditional approach to primary infringement of copyright, namely to say that it is strict liability with no mental element, on the contrary, in those cases, the Court of Justice has started to incorporate into its analysis some degree of mental element on the part of the defendant. And so, at least in that sort of context, the Court of Justice is saying this is not a pure question of strict liability, whereby you infringe copyright regardless of your mental state. On the contrary, your liability may depend, at least to some extent, on your mental state. Now, the effect of those two contradictory movements, on the one hand of enlarging the scope of primary liability in terms of the breadth of the right of communication to the public, but on the other hand, as it were, narrowing it by reference to the mental state of the defendant, as I say, is a little contradictory. Where is this going to take us? Well, I think it remains to be seen, and I think we'll be learning more from the upcoming references, particularly in the YouTube case, and one or two more that are following on in the wake of YouTube. But let me give you one possible answer which the Court of Justice may arrive at, although this is pure speculation on my part, which is that the Court of Justice may be slowly, bit by bit, developing a doctrine which amounts to a doctrine of accessory liability in this context. And the analogy I would draw is the way with which English law has approached this question. If you look at accessory liability for intellectual property right infringements under English law, what you find is that the conditions for primary liability are laid down in legislation. So in the copyright field, we look at the Copyright Designs and Patents Act 1988, and it tells us very clearly and very precisely what constitutes infringement of copyright on a primary basis. And we have parallel provisions in the context of patents, trademarks, designs. It's all laid down in legislation. But when you come to the question of accessory liability, you find that our legislation is almost entirely silent. There is one small exception to that, which is the question of authorization in copyright. But if you leave authorization in copyright aside, the legislation is silent. And what the courts have done over the past 100 years and more in England is to fill that gap by constructing a doctrine of accessory liability as a part of what we call common law, that is to say, judge-made law. And in a step-by-step incremental fashion, the courts have built up a doctrine of accessory liability in the field of intellectual property right infringement, which essentially applies the same principles that we apply under English law to other torts. And so it is that you can be liable for copyright infringement and indeed other forms of intellectual property right infringement under English law, both through primary liability as laid down in the legislation, but also you can be liable as an accessory, someone who participates in an infringing act without being primarily liable under the conditions laid down in the case law. And it is possible that where we will arrive at through the jurisprudence of the Court of Justice may be similar, in that there will be laid down in the directives as a matter of legislation the conditions for primary liability as a matter of EU law. But when it comes to accessory liability, we will be looking at the, as it were, EU common law established by the Court of Justice's case law. But as I say, that's my speculation as to where we might end up. We have to wait and see what the Court of Justice says in YouTube and the forthcoming references.
Thank you very much. You were also faced with the question of Pirate Bay operators' liability, and you found them liable as accessories. If a case like that was litigated today, what would you do?
I can't see any reason why I would reach a different conclusion.
Okay, thank you. Nick, what is your take on this evolution?
Well, I think Richard's right. I mean, it's interesting, this idea of a kind of EU common law, but in a way it really is developing like that. Well, it's a bit sad that the Court of Justice never grappled with the intermediary liability issues in the Pirate Bay case, because there were two questions referred in that case. The first one was, is it communication to the public? And the second one was, what about Article 8.3 of the Information Society Directive, and what about Article 11 of the Enforcement Directive? And it was those issues which all the interveners were very exercised about in the Commission, because that was really the opportunity to set the scene for how this intermediary liability should work. And most people that intervened, I can't remember whether it's absolutely everyone, but pretty much everybody who intervened felt that this wasn't communication to the public in the Pirate Bay case, because the Pirate Bay doesn't actually communicate a work, it just tells you where to go off and find the work. It's a bit like a sort of yellow pages of infringing websites, essentially. So there is there was a big opportunity missed there, and I think it's that the law has sort of not taken an entirely even path from as it's developed from there, and you know, it's, as I say, that there hasn't yet been, until we get to YouTube, we haven't yet had a clear opportunity for the court to give a ruling on this, which will be interesting to see how it pieces all this together.
I guess that another issue that remains outstanding, at least under the pre-DSM directive framework, is the issue of a safe harbor availability. If you are a directly liable intermediary, can you still claim that the safe harbor applies to your own activities or not? Because also here there is literature which holds the view that the safe harbor is available irrespective of the type of liability. So I don't know whether you feel like commenting on this, because it is another issue that of course is at the center of the YouTube referral.
I think what I would say to that is I would distinguish between accessory liability and intermediary liability. So accessory liability is where, to use some traditional English terminology, you're aiding and abetting someone who's primarily liable. You're encouraging them, you're inciting them, you're involved in some way, but you're not actually the person who is physically doing the restricted act. Now, the point about accessory liability, certainly as we view it in English law, is that your liability is joint and several. That is to say, you're equally liable with the primary infringer. And in particular, what that means is that you are liable, firstly, for damages for the past acts, and secondly, for an injunction to restrain you from repeating the acts in the future. That is to be distinguished from intermediary liability under Article 8.3 of the Infosoc Directive and Article 11, third sentence of the Enforcement Directive, because that is liability for people who qualify as intermediaries purely to injunctions, not damages for the past. Because you can have an injunction against an intermediary, even if they are not liable either for primary infringement or on an accessory basis. So one needs to distinguish between those two things. So far as the question of the safe harbour is concerned, it's very clear that the safe harbour does not protect an intermediary against an injunction under Article 8.3 or Article 11, third sentence of the Enforcement Directive. As to protection against accessory liability, there may be some room for argument on that, but I think on the whole, most people take the view that where the safe harbour applies, then you are protected against accessory liability.
There is a question from one of the participants who asked about the future of the safe harbor under the new copyright directive. As you know, Article 17 touches upon the role, responsibility and potential liability of online content sharing service providers, and states that the safe harbor will not be available in relation to copyright infringements, but remains potentially available for other types of liabilities. So I don't know whether you feel like providing a comment on this new piece of legislation, which the UK so far has decided that it will not transpose, or shall we move on?
I think I'll pass on that one for the reason that you've just identified, namely that as matters stand, it's academic in the UK, although of course that might change for reasons that everybody knows about in the future. But as matters stand, it's academic. I can only sympathise with those courts in the EU who are going to have to grapple with that question in the future.
Okay, let's now move then to the next topic, which is the interplay between copyright and other fundamental rights. This is something that has been quite dormant for a long time. There were timid references to the EU Charter in some cases. For instance, one that comes to my mind is the Luxan case, in which the Court of Justice very briefly hinted at the fact that if you don't recognize the director of a film as an author of the film, then that is a deprivation of intellectual property contrary to Article 17 of the Charter. So over time, we have gone from very niche references to an increasing body of literature, cases concerning the interplay between copyright and other fundamental rights. And last year, the Court of Justice issued its 3 rulings on this topic inter alia, which are the rulings in Funke Medien, Spiegel Online, and Pelham, which incidentally were decided by the referring court last week. So the question that I would like to ask Nick is where we stand now in the relationship between copyright and other fundamental rights.
So I suppose the starting point with this is that most IP lawyers were not really terribly accustomed to looking at fundamental rights or human rights at all. The cases where they tended to have any role to play were ones where people were trying to cook up additional defences to avoid an almost inevitable finding of infringement. There's famous arguments like the one run by Tesco that it had a fundamental freedom of expression by using the sign Levi's in connection with parallel imported jeans. Since then, those sort of earlier cases, we've had the Charter of Fundamental Rights that came into force with the adoption of the Lisbon Treaty. And the point about the Charter of Fundamental Rights is that it forms part of EU primary legislation and has exactly the same value as the EU treaty. So it coexists with the general body of EU law. And the Charter itself says that it applies when member states are implementing EU law. That's the language in Article 51. Now, one might have thought that a member state is implementing EU law when it's, for example, transposing a directive into national law. or directly applying EU law. In actual fact, the Court of Justice has ruled in 2 very important cases, Maloney and Franson, that fundamental rights guaranteed are applicable in all situations governed by EU law. So the upshot of that decision is that the Charter applies whenever there's a situation governed by EU law, and it sits alongside the treaty in every single case. Now, what does that mean for copyright? Judge Malinowski and various other judges at the Court of Justice have kind of been at the fore of looking at the balance between those fundamental rights, between the rights of the right holder and the potential rights of the defendant in copyright cases. And quite a lot of those cases, the older cases, were quite easy to hit that balance because you were dealing with the rights of a right holder versus a right to property versus a right to somebody to carry on a business counterfeiting goods or making otherwise obviously illegal copies of some, you know, the Pirate Bay having its Charter of Fundamental Rights interests it's not going to detain a court particularly long trying to balance those rights. But there are kind of bigger issues which came to the fore. They also raised quite difficult questions about how member states balance these Charter of Fundamental Rights issues with their own constitutions. And some member states, not the UK obviously, but ones with a written constitution, have had to wrestle for some time as to how EU law might relate to their own constitutional protections. And one of those courts is the German Constitutional Court, whose German basic law embodies various fundamental rights. So the German Supreme Court referred these three cases to the Court of Justice, and at the oral hearing, the Court of Justice asked an additional question, which is to ask the member states and the Commission who'd intervened what their view was on the relationship between the fundamental rights guaranteed by the Charter and those that are protected on a national level, where member states have a discretion about how they implement EU secondary legislation. So it gave, and I think this is the reason why the case went to the Grand Chamber, those cases went to the Grand Chamber, it gave them an opportunity to look at this much bigger constitutional question. How do you fit member state discretion into this context of a situation where there are implementation of optional provisions in legislation, and how do fundamental rights fit in with that? The three cases themselves, the first one, Funke Medium, was about German military status reports drawn up by the German government. The Funke Medium operated a newspaper and published on its website details of these classified reports relating to troop movements in Afghanistan. And there was an issue over whether copyright subsisted, but the court didn't deal with that. But what the court said in that case was that when you're looking at the Information Society Directive, some provisions are measures of full harmonisation. So Article 2 and Article 3 are full harmonisation measures, so no member state discretion. But the exceptions and limitations in Article 5 are not fully harmonised. And so the balance, to carry out the balancing exercise between freedom of information and freedom of the press in Article 11 of the Charter, they said that the correct balance had been struck in respect of the actual exceptions and limitations in the legislation, and they don't provide, the Charter does not provide a further derogation beyond the terms of the legislation. Now that was quite an important point, because the real question before the court, and one which was sort of lurking in the background, is what are courts to do? Do member state national courts have to balance these fundamental rights in every single case and reach possibly contradictory views about the scope of the derogation, or can they rely on the original legislation having struck the correct balance? And so the court actually provides quite a clear line for some legal certainty in these decisions by saying that actually you can't do better under Article 11 of the Charter than you can under the specific provisions in the derogations in the Information Society Directive. Next one was Spiegel Online. That's a case about a politician called Mr. Volker Beck and an essay that he wrote. There was an issue in that case about whether the essay was amended without his consent. And again, it was an issue about whether the fundamental rights as to freedom of information and freedom of the press in Article 11 could come into play. The court made much the same findings as in Funke Medium on fundamental rights. You can't justify a derogation beyond the exceptions and limitations in Article 5. So that's again quite a clear, they're drawing a fairly clear line on the basis of the Information Society Directive. Final case was Hutter and Pelham. That's a slightly more fun set of facts. That's a well-known dispute involving the band Kraftwerk. They composed a song called Metal auf Metal. Moses Pelham, who was the defendant in that, sampled that's part of that song, and then used that to make a new track called Nur Mehr. And 9 years this litigation happened it took in Germany to reach the German Supreme Court. Eventually it was referred to the Court of Justice. And the issue in that case was, how do you apply the exclusive right, the economic right in relation to phonograms? And the court held that the correct balance applying the Charter is such that even if a sample is very short, if it can't be recognized, it can't be reproduced unless the sample's included in a form unrecognizable to the ear. Quite what that means is open to a lot of debate, I suspect. And it's the balance of rights that led it to that conclusion. So again, we've seen in all these cases this balancing exercise, but perhaps not in quite such a fundamental way that many people had thought might have been carried out before. And it seems that member state courts, although they're required to consider the application of the Charter in every case, can to a certain extent rest, certainly in these specific examples, rest fairly happily on the way that the balance was struck in the legislation itself. So they're not it isn't necessary to rewrite the legislation in every case, which is hopefully quite reassuring for the judiciary of most member states. But quite how this will go on to be applied going forward, I think in the right kind of cases, and you take Pelham and Hutter, that's quite a tricky case for fundamental rights. You know, do you protect the original author of the original work as against the right to create new derivative works? They're not quite as easy as some of these older cases where you have an obvious argument that the defendant is infringing rights or is operating a counterfeit website or something. So we'll see how they develop, but it's certainly now very much part of our law, and in appropriate cases needs to be considered, and particularly when you're enjoining people, people seeking injunctions, part of that balance is an important aspect of considering how to grant the relief potentially.
Great, thank you very much. The question that I have after reading these three cases relates, among other things, to the issue of exceptions beyond the list of Article 5. Considering the increasing inflexibility that the Court of Justice has displayed towards the system of exceptions, increasingly said that they are autonomous concept of EU law, so everyone must say what a parody is in accordance with the Court of Justice case law, the issue of a strict interpretation, but also effectiveness. So overall, an increasing tendency towards the court to warn member states that the freedom that they have also in transposing Article 5 is not as great as many thought that it was. So I wonder how surprising it is, the conclusion that member states cannot open up the system of Article 5 and envisage exceptions beyond that closed list. Is that a surprising conclusion in the end, also in light of a preceding case law?
Well, my answer to that would be it's not in the least surprising. It's entirely in accordance with the processes that we've seen elsewhere in the Court of Justice's jurisprudence that we've already discussed. So it parallels precisely the developments since InfoPac and since FLOSS. And the Court of Justice's approach throughout is the same, namely to adopt a strongly harmonizing agenda. And what that leads to is preemption of EU law over national law. So more and more areas of copyright are governed by EU standards, and therefore national standards cannot differ from the EU standards. So from that perspective, I think it's not in the least surprising, and it's consistent with the Court of Justice's overall approach. That said, I think we need to be clear that although the Court of Justice has a strong harmonizing agenda in the sense that it is, as we've discussed, laying down EU standards to be applied, that is not the same as dictating answers to national courts. On the contrary, it seems to me that the EU standards that are laid down by the Court of Justice are ones which contain considerable flexibility for national courts when deciding individual cases. It's simply that the national courts must apply the EU standards rather than standards derived from their national traditions.
That is absolutely true, but I would also argue that in some cases the CJEU has actually hinted at what the answer should be when it comes to precisely the case that has been referred. A clear example, I would say, is the Deckmin case concerning parody. The response of the CJEU really can be applied without too much thinking to the background proceedings, because the CJEU had come to the conclusion that a parody like the one in the background proceedings would be against these fundamental values of the European society, which are referred to in the ruling. So, coming to an end of this seminar, I think that the fil rouge has been indeed somewhat a unitary lens that the Court of Justice has been using to decide different types of cases. More or less, similar approaches and patterns can be discerned in different areas of copyright. So the question that I would like to ask to our speakers is a bit of a crystal ball gazing exercise. What you think will be the next big issue for the Court of Justice to address?
Well, personally, I think the big ones are the ones that we've already touched on. So we've got the next step with the copyright designs interface in the Brompton case, and that's going to be an important decision for the reasons we've touched on. And we've got the next step, so far as communication to the public is concerned, with the YouTube case. I think those are the big areas in the immediate future, although there may well be other ones coming along as well.
Nick?
I agree with all of that. I think the interface between IP rights has always been a sort of classic problem, but you know, the interface between trademarks and designs and copyright and trademarks and copyright and designs is I mean, they'll have to grapple with these issues. One of them, they came up a little bit before the EFTA court, but so far the Court of Justice hasn't had to rule on those, and it's be interesting to see. Brompton is one of the first opportunities to really get involved in that.
I guess you are referring now to the Vigeland case, which was decided by the EFTA court not long ago.
Yes, that's right. Yes, yeah. So that's whether you could then continue in protection using trademark registrations for things that had where the copyright had lapsed.
Perfect. While if I may venture a bit beyond these cases that are now pending, I would say that perhaps one of the next big questions for the CJEU, I expect that sooner or later it will be asked, will concern the other basic requirement for copyright protection, that is authorship. If you look at the InfoSoc directive, the right of reproduction is granted to authors in respect of their works. The right of communication is given to authors, but there is no definition whatsoever of who an author is. There are some hints in other EU legislation, such as the SATCAP directive, database and software directive, but no general definition. And perhaps similar to what has happened in Levola Angelo regarding the notion of work, perhaps at some point there will be a national court asking the CJEU to identify what the requirements for authorship are, which is something that might be pressing also in light of the fast-paced technological advancement. We speak a lot about artificial intelligence creating works, etc. But I guess also on more analog issues such as joint authorship. Who is a joint author? Now, in the age of COVID, we are seeing newer examples of potential joint authorship. The example that comes to my mind is the following. Since all photographic sets are being closed, increasingly there are photographers who direct models in their homes to take photographs of themselves using FaceTime. Are these models joint authors or they are just acting at the direction of these photographers? So we are seeing in the US a lot of paparazzi photographers lawsuits as well, in which models like Gigi Hadid have been claiming that they are joint authors of these shots because their job is to model for a living. So I see an interest certainly in the US, but I guess also in Europe, and perhaps that will be the next question for the Court of Justice to address. I think that we have come to a close of this seminar. There is a comment by Aaron saying, only an EU IPO case, but Bansky has applied to register a number of his artistic works as trademarks. Might be worth keeping an eye on those. This, I guess, goes back to what Nick was mentioning regarding overlapping IP rights. And here there has been an attempt by Bansky to use trademark law. Bansky is an artist who in the past has claimed that copyright is for losers, but he doesn't seem to share the same view about trademarks. Okay, thank you very much to both the speakers. It has been a great honor and pleasure to have you here, and thanks very much to all the participants for dedicating their time today to this event. Let's hope to go back to meeting in person very soon, and thanks so much for being with us today. Thank you.
Thanks very much.
Bye.
Bye.
Bye.